Hello, our dear members. It's that time of the week when we embark on our member education session today with a very special topic at hand. And I know that we did invite you and you have heeded to our call. Thank you so much for all of you who have made your time and dedicated this moment so that we may be able to share knowledge with one another and so get enlightened. Feel most welcome at Maisha Bora Sacco, tuungane kwa Maisha Bora. And I've seen quite a number of us already on board. I can see you, Mr. William Wanjama, all the way from the United States of America. Feel most welcome. Jane Wangari, Christopher Mtunga, Christopher Menzo, Bwana Victor Katulwa, wote karibuni sana, tuungane kwa Maisha Bora. And just as more of our colleagues join us, we are going to have a very, very special presentation today. I know that in other jurisdictions, it will always be an assumption that, the law is always clear. But here at Maisha Bora Sacco, we never take anything for granted, not unless we listen from the horse's mouth. Therefore, feel most welcome at Maisha Bora Sacco, a very, very interesting evening, or rather morning, depending on your time zone, where you are getting us from the number one Sacco of your choice. Let us feel at home. Let us feel at Maisha Bora Sacco, tuungane kwa Maisha Bora. Shortly, we shall be setting off to begin our program, and just allowing 1 or 2 minutes to our colleagues to join us this evening. For those of us already here, let us get set, get somewhere to take notes, and also we shall be sharing the registration link, whereby in case you have got any more pressing issues, then you'll be able to register on that link, whereby you'll need to state your member details, and also if you've got a question, a comment, or any feedback for us. Karibuni sana once again here at Maisha Bora Sacco. Just in a few seconds, we shall be set to begin, and we are going to begin with a prayer. So those of us joining us, let us tell a member to tell another member that it's already getting down for our session today. Let us feel at Maisha Bora Sacco, tuungane kwa Maisha Bora. If you are joining us from within the country, you are in Nairobi, Naivasha, anywhere in the country, you are in the diaspora in Qatar, you are at the United Arab Emirates, in the US, in the UK, feel most welcome on board. So now, we are set to begin, and we are going to pray for the session. Then we shall officially kick off our very, very interesting topic of the day. Let us pray. God our Father, we come before you this evening. We do appreciate you for everything that you have done for us, everything that you continue doing for us, and your never-ending blessings upon us as members of Maisha Bora Sacco. We appreciate you for this far that you have brought us, and also for the milestone that we have covered as Maisha Bora Sacco, giving us over 50 years in existence, in operation, and in achieving value to all our members. We thank you for our dreams and our aspirations. More so, we thank you for our esteemed members who have gotten time to join us for this session. It is a moment that we have really been waiting for, and finally, it is here with us because of your grace. Therefore, we call upon you, O God, that through the power of your Holy Spirit, may you be part and parcel of this session. We pray that may you give us the wisdom, knowledge, and the power of understanding that even as we are taken through the session by our facilitator, we may be having many points to take home. Let your will be done to us, and may you continue giving us the energy and the strength as we are esteemed members of Maisha Bora Sacco. May you help us to realize our financial dreams. Through Jesus Christ our Lord, we do pray, trusting and believing. Amen.
Amen.
Asanteni sana. Thank you. Feel most welcome. Feel at Maisha Bora Sacco. Tungane kwa Maisha Bora. Those joining us just right now, just from the brief introductory remarks, we had stated that everywhere you will go, people will tell you that, you know, the law is very clear. But here at Maisha Bora Sacco, we leave no stone unturned. That is why we embark on this trajectory, that we may be able to understand more pertaining what the law says on guarantorship. And by the way, you know, in every legal jurisprudence, there is always a lacuna. And that is why we shall have everything clearly explained to us. Without further ado, allow me to welcome Mr. Mbae, who is going to welcome our facilitator of the day. Welcome, Mr. Mbae.
Thank you, Emmanuel, for the opportunity. Our members are once again welcome to today's session. I will have the honor and the pleasure to introduce our facilitator for the day today, Wakili Wanjiku Thiong'o. She's a charismatic and energetic advocate. She's been an advocate of the High Court for the last over 8 years. And she's the founder of Thiong'o Law Advocates, a law firm based in Nairobi. Over and above that, she's a member of Law Society of Kenya, a member of East Africa Law Society. She's also a commissioner for oaths and notary. She's also a director at KENHA, that is a Kenya National Highways Authority. And definitely she's a holder of bachelor's degree in law, of course a graduate from Law School of Kenya, and also an accountant by profession. So welcome, Wakili, to this session. Our members, let's be attentive. This is a very important topic, that is basically the law on guarantorship. You've been asking for this session, and we welcome you to pay attention to our advocate, listen to the presentation, and also get an opportunity to ask questions where it's not very clear. Once again, Wakili, karibu sana. Where I have not, probably where I could have missed on your titles, you can proceed and also do your own introduction. Karibu sana, over to you to take over the session.
Thank you. Thank you, Bae, for the kind introduction. The kind words, it sounds like a very long list of who I am. But to simplify it, and thank you, Emmanuel, for today's invite. To simplify it, I'm an advocate of the High Court, consulting with various financial institutions, including Saccos, and more particularly Maisha Bora. We may have interacted with a number of you, because I consult with Maisha Bora. I'm also in your panel of lawyers, and we may have interacted in one way or the other. But today we are here to discuss about guarantorship. I will not burden you with the legal jargons, with the heavy words. I want to simplify it so that as members, I'm equally a member of the Sacco, so that as members, we know before you sign that guarantorship form, what is it that you need to know, so that you are a smart guarantor, so that your savings, your investment are safeguarded and protected. And before, as they are running the slides, maybe we all joined the Sacco for a purpose. That's what I believe. At one point, maybe a friend of yours took you to a Sacco and said, you know what, I've been saving with this Sacco, which I keep saying. I keep telling my friends, I'm a member of Maisha Bora, you guys need to invest with them. A friend took you to Maisha Bora or to another Sacco, and you joined, started saving. Maybe you are tired, for ladies, maybe you are tired with the merry-go-rounds because treasurer alihepa na mchango. And that's how you joined the Sacco, because you felt it's a safe way, it's a safe place to keep your money. But more particularly, we say Saccos, it gives us, or it serves two main purposes: for us to save, and more importantly, to take loans so that we can grow. And Maisha Bora has been doing that. And when we are talking about loans, Emmanuel, maybe you can assist with the slides to start running. And when we talk about loans, definitely this is members' money. And the Sacco has an obligation to ensure that the money is safe and the money is safeguarded. In doing so, when you are able to access these loans, and that's what I was saying, the purpose of joining a Sacco is to save money and to access affordable loans. And definitely when you join the Saccos, you're in other financial institution, when I talk about affordable loans, you know what we are talking about. The interest rates are favorable, the terms are quite flexible, and all that. But what you are taking from the Sacco is members' money. And the Sacco has an obligation to ensure that this money is safe. And in doing so, they always ask for a security so that in case of default, the members' money is protected. And that can come in two ways. The most common one being guarantors, which is where we come in as members collectively. And the second one is collateral. Maybe Emmanuel will do another day for collateral so that I explain the nature of collaterals we have in place. What are your rights when you are giving out your collateral and all that. But for today, let's limit ourselves to guarantors. And being a guarantor, and before we come to who is a guarantor, there is the Sacco Societies Act, Section 33, which provide for the loan, for the application of a loan or credit facility by a member. And importantly, the law allows that the loan can be guaranteed by a person who is a member of the Sacco. We can move to the next slide. And with that, we can first define who is a guarantor. In simple terms, and to start with, a guarantor must be a member of the Sacco. And when you are a member of the Sacco, you then pledge your shares and your deposits to guarantee or to secure the loan in favor of another member. So that it becomes critical, because when you are guaranteeing someone, when that form comes, it looks a very basic form. And you are signing off, you just put your name, you indicate the amount and you sign, then you enter into a binding contract with the Sacco. What do I mean by a binding contract? It becomes enforceable. That loan is disbursed to another member on the strength of your signature. So that in case this person defaults, the Saccos right accrue to deduct your deposit in case of default by the borrower. So simply put, a guarantor is that person who will sign on behalf of another, taking responsibility, taking liability, that in case of default, then your shares or deposits, to the extent to which you signed, will compensate for that default. So that what I would say as a guarantor is that you need to know the financial behavior. That's what we are saying. You need to know the financial behavior of the person you are guaranteeing. This is not meant to scare us members, because tomorrow you also need to borrow. And what maybe I needed to take us back is to say that collateral comes with a cost. Those who have placed collateral with the Sacco, we have perfected your security. It could be land, it could be motor vehicle. It comes with some cost. But I can say guarantorship, say for the what may happen after, I could say it is almost cost-free. Because all you need is get a member who is in good standing, whose their shares are available, deposits are available, and they sign off for you. So that guarantors, if all of us were to act in good faith, is the best method Saccos operate, because we have come together to create a pool from which we then borrow money. So that when it comes to guarantorship, the point to take home is that, do you know the financial behavior of the person you are guaranteeing? And not to scare you, because tomorrow you'll be the one needing a guarantor. And there is always a scenario, because we don't know, you end up joining a Sacco because you know someone in that institution or you have heard about them. And most Saccos, when they were starting off in those early years, they were always confined maybe to a certain class of people. Even I know Maisha Bora has its history, and it was at one point maybe confined to a particular class of people. We have other Saccos confined to a certain group of employees working in a certain institution. So that you say, I know this person because this person works here. But beyond this person working here, can you speak to the manner in which they manage their finances, in which they manage their investments? So that a friend comes to you and say, oh, I'm taking a loan from Maisha Bora for 1 million. I have a quick kabiashara that I need to complete. We are going to get returns quick, within 3 months I'm done. And a form comes to your way, maybe you're even colleagues at work, and you sign it off. 1 million you have guaranteed, and the money is disbursed. A few months down the line, you are getting notices from the Sacco, this person is defaulting, and you're like, oh, I thought I knew this person. Of course you knew them, but did you know their financial behavior? Only to realize the 1 million was the pressure out here to maybe enjoy some good time at the beach and have some good time, and the money is gone. It was not invested in any business. There are no returns. They cannot repay this loan. So what we're talking about is that by the time you sign off that loan, do we know the financial behavior of the person you are guaranteeing? And you can come to the obligations. I'll start with the obligations of a guarantor, which you equally, obligations comes with rights. We'll later then come to the rights of a guarantor and what you need to know. So what are your obligations when you're signing off that loan? One of your obligations is that you become a security, you provide security for the loan. In other kind of loans, you could find someone offering land, they could offer personal property, motor vehicles, and those kind of things, salaries. But in this case, you're offering your deposits and your shares as the security for that loan. As I said, it is upon this undertaking that the Sacco then disburses this loan. You have undertaken that in case of default, then you are going to repay the loan. The second obligation as a guarantor is that you take financial responsibility in case the borrower defaults. And how does it work with Saccos? When you sign that form, you have executed a contract with the Sacco, authorizing the Sacco that in case of default, and the Sacco following its processes, its procedures, in compliance with its policies, has given all the required notices, then they have the right, of course, after notifying you, to deduct your money to repay the loan. As we said, this is members' money. So that is why there is that financial responsibility that comes with signing the loan. The third one is encourage accountability among members. And this is what we say, we wish we live in a world of people acting in good faith, so that this act as checks and balances amongst members. So that if I know I have guaranteed by some he has guaranteed me for a loan I've taken, there is some responsibility or accountability to me for me to repay that loan, so that I ensure there is no legal harm that would be suffered by my guarantors. It is so unfortunate that sometimes people take loan with zero intention of repaying that money, and they are hoping miraculously they will switch off their phones and the loans will disappear. So that in Saccos, since we have come together with one goal, one purpose, to save money and take loans, is that it would be assumed that there is some kind of check and balances amongst ourselves to ensure that we repay the loans. And finally is to mitigate the risk of loss of members' funds. Because as we said, a Sacco is where we come together and pull funds from members for purposes of taking loans. So those are the major, but what we are saying, the key one is that you have taken responsibility in case of default, that the Sacco will take what you offered, could be deposit, could be shares, to repay in case of default. But what are the rights? And the first one, I think on this slide should be, this is the obligation of the Saccos to the guarantors. We can start with this. And the first one the Sacco need to do is they need to inform you the loan terms before signing. I hope Maisha Bora is doing that. You need to know how much I'm taking, what is the repayment period, and those kind of information. And even what they have offered, of course, carefully with data protection these days, if you need more information about that loan and what is being used to do, then you can request from the Sacco. Of course, they will align to what they can disclose about that person, and more particularly the loan terms before signing need to be disclosed to you, so that you know what you're getting yourself to. You don't just sign, then later on you are like, okay, what did I sign? I think we live now currently in a world, in a place where we say before you sign anything, it's good to read. The second one is that you need disclosure on the repayment status at any one particular time during the repayment period. The person may not have defaulted, but if you want to know how is the people you have guaranteed, the borrowers, how are the borrowers doing, if you can request for that information, the Sacco should be able to give you that information. And the third one is that you need to be notified in case of default. I think that happens, that you will see the first defaulter's notice going to the borrower. As a guarantor, you would be copied that you notice that this person has started defaulting, so that it is a process. By the time they are getting to recovery and deducting your deposit, it doesn't come as a surprise. And of course, that comes when your deductions have been made, when your deposits have been deducted. The Sacco also need to notify you that maybe 100,000 from your account has been deducted because this person has completed, despite demands, despite all the notices we have given, this person has defaulted. This is another critical area. What happens in case of restructuring? And it is an area of improvement. I know it's what Emmanuel was saying, there is always a lacuna in the law. I don't know whether there is a lacuna, but there is always the perception that when I guarantee you, you do a top-up, which is still within, maybe I took 5 million, I have paid 2 million, I'm left with 3 million, I still have a room for 2 million, I can top up. Do my guarantors still stand? And at this point, it is always important to notify the guarantors that the loan is being restructured, because the terms could be the same, the terms of that loan, the circumstances may have changed, so that the guarantors can actually give consent to that restructuring. Because simply put, this would look like a new loan contract between the borrower and the Sacco. The next one is that in case of deduction, we'll come to the rights of the guarantors. You are going to acquire the right, let me simply put in an insurance way, it's like the right of subrogation. When your deposits have been deducted, you acquire a right to go after the borrower for you to pursue what has been deducted, for you to be compensated by the borrower. So that when you request from the Sacco, they should be able to give you the necessary documentation, so that as you go to court, and we say the court of law is a court of evidence. You need evidence to show that this person took a loan, to show that from your statement, money was deducted. The Sacco should be able to support you with that. But I have seen an interesting situation, I would call it a very funny way of operating out here in the streets. Because I've taken a loan, you know, most people back then, when you did not know someone, you kind of come hang around the Sacco offices. I'm not saying for Maisha Bora, but even in other Saccos. Then you find someone else taking a loan. And you're like, you know what? You can guarantee me, I guarantee you. So we kind of exchange. And that's how I would get guarantors. And definitely you don't know this person so well. This person definitely maybe, you don't know, they didn't have the intention of repaying, or life has become tough, you can't trace them, and your deposit are deducted. I find a member, which I would say is out of lack of information, saying, let me also default, so that we are at par with the Sacco. They took my money, I will also be running away with their loan, which is not helping the situation actually, because your obligation as a guarantor still stand, whether you have your own separate loan. That is a totally different contract between you and the Sacco, where you are now a borrower. In this case, you are in a contract of guarantorship. But the point here is, we'll get to that when we come to the rights of a guarantor. The point here is that the Sacco should be able to accord you the necessary document to support your legal claim. The next one is that after repayment, you're entitled to be released as a guarantor by the Sacco. I believe that should be automatic. Let's come to your rights. I know we have been pushing on what you need to know, what are your obligations, your money will be taken away, but definitely what has obligations has rights. And what I would start with is that we need to know when you're guaranteeing someone, it's a voluntary process. In fact, if you feel like there is some duress or undue influence, you should stop that transaction at that point. You should be able to send that form freely. And I think you should also be very worried. You know, there are members who reach out to you because they know you're a member of the Sacco and say, you know what, I can give you some few coins or some few thousands if you guarantee me this loan. You see, there's some form of inducement, and you need to be very worried. Why? They have to pay you for you to guarantee them. You need to ask yourself is, are they really going to repay? Do I know these people, or I'm just excited about the few coins that are coming to my way at that point? But the point to take home is that no one should force you to guarantee someone when they're taking another loan. And the first right is that, is what we have mentioned, which was an obligation to the Sacco, is that you need to know the loan terms. You need to know the amount being advanced. You need to know the repayment period. If need be, the repayment schedule, what it looks like, and whatever information you need from the Sacco. Number two, you have the right to limit the guaranteed amount to a specific amount. I could have savings of 1 million, but I have the right to limit that loan to 100,000. And what is committed to that particular loan is that particular amount that I have signed to. And I believe with the Sacco forms, there will always be a column of indicating the amount that you are guaranteeing. The next right you have is that you have the right to accurate information about the loan status during the existence of the loan. I believe we have spoken about that. We have also spoken the right to be notified in case of default and before recovery is put in motion. You have the right to be notified after the deductions have been made from your account. And there is also another right to be replaced by another guarantor. But this one is a sword that can cut two ways. Because you see, you can't just walk into the Sacco and say, now release me, I want to be replaced by someone else. The borrower has the first obligation, which must be discharged to get an alternative guarantor. And the reason we are saying this is, the Sacco entered into a contract or the loan agreement on the strength of your guarantorship, so that if you withdraw without a replacement in place, which must be an acceptable guarantor, then the Sacco remains exposed. So as much as a right to be replaced with another guarantor is a conditional right, that another alternative must be available. And you have moved to the charges very fast, but finally there is the right to be released upon full repayment. I believe we have spoken about this. Let's now move to the common charges that happen. And I think even to start with, most of the common charges of guarantors, it is cases where you don't know the person you are guaranteeing. I think because you're also taking a loan and you need someone very quick, the most common challenge we have is that we do not know our fellow members in the Sacco, and you do not know the financial behavior of that person, the capability of that person, the purpose of the funds. That is a common challenge, but which maybe you cannot control because we really do not know everyone deeply. We do not know, and then sometimes it's not intentional that people default. It could be circumstances in life. Tomorrow the business has gone south, which was doing very well. So one of the main challenges I find is that we do not know the people we are guaranteeing, and more importantly, we do not know the future of what is going to happen to their businesses, to their employment. They could suffer from redundancy and all that manner of thing. But all factors remaining constant is, the first one would be borrowers defaulting, which could be for many reasons, as we have said. Some are taking the money just for not even to invest, or businesses have gone south, so it might not be intentional. And when that happens, definitely recovery happens against the guarantor. The second common charge is that, and this happens a lot, is the borrower has defaulted, change of residence, change of employment, and what happened? We are going to come to what are your remedies, and maybe I will touch briefly on what we need to know on recoveries. If your deposits have been deducted, what are your remedies? How can you go after the borrower through the right of subrogation for you to get back your deposit from the borrowers? But what happens is that you find someone, you have gone to a lawyer, has assisted you, you have even a judgment, you have a court order saying that, yeah, indeed it's true, your money was deducted, this person needs to compensate you. The biggest challenge we have as lawyers is what we call execution. Execution is where I have a judgment. You know, a judgment is just on paper, but how do I convert that to money? I look for this person. There are people actually, I would say, I think they are just easy to move. Tomorrow, the moment they know you are following them, they just move houses. They change lines and completely you cannot trace them. And if we have to trace them, it becomes such an expensive affair that you have to involve investigators and all those manner of things, so that when you look at the cost of execution, it might not be outweighing what you are recovering. So definitely the main one is the borrower changing residence, and I find this what I could say. There are people I think who are just generally cons. They just come take loans, they know they won't pay, they will start playing this monkey business of disappearing. The next one is that in case the borrower is in arrears, some Saccos have a policy that the guarantors cannot take on loans or you cannot guarantee. It will depend with the policy of Maisha Bora. In case there is a borrower, my deposits are tied to that borrower, this person has defaulted. Do I still exercise the right to borrow? Because maybe my deposit as it stood, they no longer can be said to be of good standing anymore because they are tied to a loan which is in arrears. The other challenge that comes in is Some Saccos will do some restructuring or top-ups without informing the guarantors. So I would say the terms of the contract have changed, you have not been notified, and now all along when you knew these were the terms, this has changed. So that's another common challenge with Saccos. Another challenge is that you are not able to be replaced as a guarantor until the borrower does not find an alternative guarantor. What do I mean by this? Assuming you are guaranteeing someone a loan here, they keep defaulting. You now realize, by then let me do my quick maths here, I need to get out of this situation. Chances are, even if you had co-guaranteed each other, you have fully repaid your loan, or you can even maybe offer a collateral or even find someone, because in good faith you want to repay this loan, your loan. But there is someone else who is persistently defaulting, who you are guaranteeing, and you want to get out of that. But I always ask, where will they get another guarantor when they are defaulters to guarantee them? Who would want to come and get into that risk? They will be saying, where do you want to swap me with someone else? Of course, they'll get information that this borrower is a persistent defaulter. So it becomes a challenge that you already guaranteed someone, the Sacco has already dispersed their own, but you cannot get an alternative guarantor because everyone is playing safe with this borrower. And finally, although we'll get a solution to this as we move forward, is where you know my details, you know my ID numbers. These ID numbers are all over. You get into even malls, you're always indicating your ID number. Phone numbers are out there. You know my signature because maybe we work in the same office. So on the form, someone just use your details and fraudulently sign for you. But as Saccos, will be coming to how to strengthen your policy about the two-step verification to ensure that it is indeed genuine. Let's come to the remedies. What happens? You have entered into this contract, the borrower persistently has failed to repay the loan, your deposits have been deducted. What can you do? You are at that point. And the first one, hoping the borrower is sober, is to approach them and amicably agree on how they can repay you. There are people who are good, and I always say, those whose business or employment went south with the factors beyond their control. They are not cons. That person will be saying, I acknowledge I owe you money, your amount was deducted, I will repay you. They'll come, agree on a repayment plan, and they repay you, which is good. Of course, we may suffer some losses of interest here and there, but since we are human, we could say that this way you cut your losses and say, it could also have happened to me, and they repay you. That is the most amicable and how we expect things would move. But there are people persistently, completely, who would even block you. You send them text, they don't respond, you call them, they have blocked you, you try a different number, they block all those numbers, you try to look for them, you can't trace them. So what can you do? The first step, and as required by the law, is to give them a demand. For recovery of the deposits which have been deducted. There are those when they see, I don't know whether lawyers these days we are returning a lot. Back in the days, if you received a letter from the lawyer, you wouldn't sleep. But these days, I think they are like, okay, anyway, even lawyers live among us, what will they do? It could also be, we have also become more enlightened. At least we also know what our rights. Even when you go back at home, young kids, they know, they'll tell you, no, it's my right, I can't do this, you can't do this and that. So I think the demands these days are not threatening much. But back in the days, when people would receive demands from lawyers, they would panic and come forward and repay. But what if that also fails? The next step would be for you to move to the tribunal. I know there is a mistake people do. People always thinking, let's meet in court. You know, there is that phrase, you'll meet me in court with my lawyer. Let's meet in court. But the channel is the cooperative tribunal. You can approach the tribunal either by yourself, if you have legal knowledge on how to do that, or you can get a lawyer to assist you with these processes. This you can do jointly as the group of guarantors whom you have been affected by a particular loan. Let's say you are a loan had been secured by 3 guarantors. You can come together, move together. But that does not stop you also to moving a loan because your contract with the Sacco was individual, if I put it that way. It was not joint. It was everyone had guaranteed for a particular amount using their own deposits. It could also be, I have seen my Shabora doing something very good, that when someone has defaulted, they also have a claim against that person. They have already deducted from the guarantors. they also have a claim. They say we want to institute a case against this. Then they reach out to the guarantors who might be willing to join the case, which of course, since there is the legal cost, Maisha Bora take care of that cost because they have also an interest in that claim. And they together they become as claimants, being the Sacco plus the other guarantors, and that is how we frame the whole case. So that you present it together. But that does not take away the fact that you have to wait for the Sacco to present a case for you. Actually, if the Sacco has no case against that person, if the Sacco has fully recovered its money, then it cannot bring a suit against that defaulter. But where the Sacco still holds a claim, maybe deductions were done, there is still an outstanding amount, they may have a claim, or they'll have a claim, and they may join all the guarantors whose deductions had been done, and they join in that case. When they come together or individually, we present a claim before the cooperative tribunal. There is court processes, and I think that's also what we need to prepare members, that the court processes in Kenya, the rules of justice tend to be slow in this country, but definitely you will get your judgment. So we present a claim before the tribunal, suing that person. One of the challenges we find with the tribunal cases or the court cases, let me use the word court because it's frequently used, with our court processes, is the challenge of fighting the defaulters. Because as I said, this person may have changed their phone number, may have changed employment, may have changed business, may have changed residence. And that's what I said, before you guarantee someone, do you know this person? Actually, there are people who come, and the match, when I ask them who is the defendant, who would then be the borrower, the only thing you have is a phone number. Then I'm like, how do we now, you know, when of course I call and I say, oh, this is Thiong'o Law Advocate, they just block my number. We use another advocate number, they'll block all the numbers. But do you have information how we can trace this person? And because there is no court process, will proceed without us having the court papers or the tribunal papers against the defaulter. And once we serve them with the papers, the process, the court process starts, there will be mentions, finally there will be hearing. But what I can say, some of these cases tend to be very straightforward because this person, the loan was disbursed, they did not repay, there were notices from the Sacco, and that's what we said, the Sacco also should support you by providing the necessary documentation for you to support your case. You have your statement showing deductions were done, and definitely, then the money is due. It's a very straightforward, I would say it's very straightforward cases, then we get a judgment. When we get a judgment, I always say actually post the court process or post the judgment is where actually for lawyers we have a headache. Converting that paper judgment to money is a problem because we now have to look for this defendant, and the mere fact we are getting all the way to judgment is because this person has no interest of paying. They're already running up and down, again hiding and all that manner of things. Because someone who has the intention of paying, the moment we give you the first demand, they always come forward and say, I'll be paying 10,000. Someone of goodwill will be saying, I'll be sending 10,000 every month until I repay. That's a person of goodwill, that's someone who is human or is capable of paying. But the moment you are going through the entire court process, from my experience, generally, this is a person who is hoping this debt will not be recovered from them. Miraculously, it will disappear. So that when you go to post-judgment, there are processes of execution. If we can trace where they work, we can attach their salaries. If you know the asset, maybe they have a motor vehicle, they have land, there is a process of sending that to auction and the money is recovered. There is also the process of civil jail. This is where someone is committed to jail for 6 months for not repaying the loan. Of course, jails in Kenya are not so interesting. So the moment you know you're going to prison tomorrow for committal to civil jail, and knowing that the food is not interesting anymore, people tend to now surprisingly find money to pay. So there is always post-judgment is having, but which is provided by the law, is the mechanism of making this person pay, which is also not an easy process. But generally, that is the whole process that you need to know. There is the legal cost implication. Generally, the lawyer may charge you. The tribunal, of course, government fees will accrue because there is tribunal filing fees which will be required to pay. But importantly is to say that this cost also always will be recovered from the judgment, the cost you are going to incur. So all is not lost. So it's not like you have lost your money and you will incur some more money for you to recover your money. So definitely there is a process of recovery. But as I was saying, when Saccos were formed, I tend to believe they were formed with goodwill. with the people coming together because they have a common goal to achieve. And maybe no one ever thought that someone would take a loan and disappear with the members' money. But here we are. And that's why we have the law in place for us to protect people from people who have no intentions of repaying. So finally, I think, I don't know whether my time is out or we are still within time. Yeah, so I can touch on the best practices to strengthen the Sacco policy. This is more importantly for the Sacco. And the first one is how we limit the guarantorship per member. And that's what I was just sharing with Bae on what is the policy. And I think he explained it is 3 times your money, 3 times your deposit. And the reason for limiting the guarantorship is twofold. One, if the deposit have been over-utilized, have over-guaranteed so many members, maybe you have guaranteed over 20 members, is that security still valid? That's what we asked ourselves. And as you always look about yourself, always know that this is members' money. You need to think about others. And that's how we need to look at it from the Sacco perspective. And the other one is also to protect your money. The more you expose your security, the more then it's prone to recovery. Because the more people, is the maths we used to do in school, the probability. The more people out there you have guaranteed, the more chances of recovery, because either of them you have increased the chances of defaulting. The second one is that we need clear legal documentation to support the guarantorship. I hope our documents are airtight, so that they need to be simple, so that people know what they are signing, but also at the same time, there is no room for ambiguity. So that we are not in court fighting about what does this clause mean. This comes to the issues of drafting of our contract documents or drafting of the guarantorship forms. They need to be airtight so that in court we are not arguing about is this, and you know, this is also to protect the guarantors in this case. They are not fighting about the drafting of clauses. We are discussing was money deducted or not. When you have airtight document, the question will be was money deducted or not, and not going to the clauses. The third one would be the disclosure of loan terms before signing by guarantors. Let's have systems where our guarantors are informed about how much they have guaranteed. What is the entire sum? Actually, you could be guaranteeing 100,000, but the entire sum could be 10 million. Let me know that this person is facing this financial burden. And if I know their financial behavior, I will know whether they can come through and repay the loan. I had alluded to this point, but now let me explain it further. I hope we have the 2-step verification of confirmation of guarantors. This could be physically signing. And this we have said they're experts in forging signatures. But what is that personal verification that you can link it to me? Could it be through a text, which I'm required to respond? Would it be through an email that I'm required to respond? I think to cover members from this kind of fraud, let's also ensure there is a 2-step verification. The other one is to notify the guarantors in case of default. I believe this one is happening before recovery is done. You'll see the first defaulters notice. I know it's not your obligation as a member to assist the Sacco to push members to repay the loan, but when you get these notices, it's also a signal to you that we need to push our friends to repay the loan, because we know the consequences. If they don't repay, then my deposits would be deducted. It gives us an opportunity to act before the real recovery comes in. And finally is the clear procedures and guidelines for recovery in the case of default. What happens? And this comes in with, and this, we also need to know what you are signing. There is when you sign jointly, there is when you sign severally. When you join jointly, and it will depend with the document you are signing, it would mean when we have default, when that person has defaulted, jointly we are liable. That is to say then, our money would be deducted equally. Severally means, actually my whole deposit can be taken away and they have not touched the other person. It becomes discretionary. So let's know what also as members we are signing. But those procedures need to be clear so that members know when someone default, where was it that my deposits were the one deducted and buyer's deposit who was a co-guarantor were not deducted. But also the guidelines would be guiding the Sacco on how to deduct this money. How far can they deduct my money before they deduct for the borrower as well? Have they exhausted that? These are the clear procedures we are talking about that need to be informed to the members so that they are aware. And more importantly, a good practice is what we are doing today, is education and training to members so that they know what they are getting themselves to. This is the support we are offering to our members, and is part of the, as we make our financial investment and decision, we are well informed. Another one, although I had alluded to this, is to notify and get guarantors' consent in case of restructuring. Because as I said, when we restructure, it will be construed like this is a new contract. And it's also good to inform the people who are in the first contract to give consent. Are you agreeable to the new terms that we are not doing top-ups, we are not restructuring? Maybe the interest rate has changed. Maybe the financial burden is heavier for this person, so that I need to give consent to that. And finally, let's have guidelines on how guarantors are released. Do we inform them that this person has fully repaid and now you are released as a guarantor? It's good, it's for good order. Information is good so that members know what they are supposed to do. So as Sacco, I think we can always strengthen, and I also say things about policy, they are not static, because every day the financial space we operate in keep changing. The space Saccos were operating in the 1970s, even when they started in the UK, is different from how we are operating today. So that our policies then need to keep changing. How often do we then review our policies so that it reflects the day-to-day experiences we are having as members? So let's keep picking what are the challenges, what are the solutions, and what need to be reflected. And it's not everything that will be in the policy, but what is it that need to be anchored in our policy and in our governance. And I believe that's it. The presentation, I have tried to simplify it as much as possible so that I don't want to draw in what the law says, the cases, the fights people have in court. It's just to simplify. What do you need to know? The fight for lawyers leave it to us. That's why we are there, so that we'll fight for you those fights. But what you need to know, that's what you need to know. I have tried to simplify it. Thank you. Bye, Ed Emmanuel.
Thank you. Thank you so much, Wakili, for taking us through this presentation. And all of us on board, kindly, you may ask your question, any question that you feel you need clarification from Wakili. She's still here. And by the way, she's also an esteemed member of Maisha Bora Sacco. So she is our colleague and one of us. So just allow me to check through the chat if there is any question that has been posted via Zoom. Those joining us through YouTube as well as Facebook, feel most welcome. Feel at Maisha Bora Sacco. Kindly ask any question that you feel that Wakili may expound on it. So just allow me to run through the chat for Zoom, then we shall be checking the questions emanating from Facebook. So just in a moment. So Doreen, you are making a recommendation that what about an email to the said guarantor for confirmation or verification before releasing the funds? Yeah, that is a practice that we always embark on, the two-step verification that Wakili spoke about. And another question. So to you, Wakili, what happens if someone passes away? Do the guarantors have to pay the remaining loan in full, or does the Sacco have insurance for this? Yeah, the Sacco has got insurance. I think that was a direct one. Thank you. James Jerry, you are asking if the defaulter, can a defaulter use a title as a loan recovery? A title as a loan recovery? Then let us run through the other questions on Zoom. Is it okay for the Sacco to follow up on only one member to deduct 2 times because the other guarantor doesn't have shares because I have been a victim? Thank you. Wakili is noting our questions. She will be able to respond to them. Talk about a closed and open guaranteed amount. Closed and open guaranteed amount. Thank you. When a member guaranteed defaults, and as a guarantor, I sent email to start paying the loan monthly for a certain period. Is it okay?
When a member guaranteed defaults?
When a member, let me just open the question once again. When a member guaranteed the defaults as a guarantor, I sent email to start paying the loan monthly for a certain period. Is it okay? Okay. And Christopher Mutunga is asking, are there times when auctioneers are called in? Are there times when auctioneers are called in? So I think Wakili, you may respond to those as we will be later on going through the questions from Facebook.
Okay.
Welcome.
Yeah, I think Emmanuel has touched on the first two. The two-step verification is always advisable when he has confirmed the Sacco has that. What happens in case the borrower passes away? Of course, ordinarily loans are secured through insurance, but you also need, those are the kind of information we have said as a member you need to confirm, because also those insurance contracts have limit. And a good example would be, an insurance contract would be saying that sometimes it goes maybe with age. They say if you're above 60 years, you cannot take more than this amount. Of course, it's a risk. There must be some financial risk that must be mitigated. And in that particular case, as a member, maybe they don't qualify for the insurance, but maybe the Sacco has an exception of how that member, considering his financial capability, then still qualify for a loan. Those are some of the scenarios. So as a member, you need to confirm before signing, is this loan one that is secured through the insurance? Of course, the Sacco would be having an insurance in place. Then there is a question about defaulter can use a title as loan recovery. The question wasn't so clear, but can a defaulter use a title as loan recovery? Do you mean that you offer a title? Let me maybe interpret the question in different ways so that you try and respond. Do you mean that a defaulter can come and present a title to the Sacco as part of the security? This is what we say, maybe an alternative security can be offered if the guarantors want to be replaced. We said if there is an alternative security available, maybe I needed not limit it to guarantors, an alternative security is offered. If it's an acceptable title, then the Sacco can accept that. And of course, the guarantor would be discharged. But also at the same time, do you mean that in case someone defaults, as a guarantor, can you go after the assets, which in this case would be a title of the defaulter? As I said, that would only come after you have a judgment in place, because it's only through a judgment that you can attach people's property. So that's how I can interpret that question. It wasn't so clear. What do you mean by closed and open guaranteed amount? I don't think there would be an open amount. What I would expect, so that it is clear in any security, a security must indicate how much that security secures. As a guarantor, how much have you guaranteed? It can't be open, because in the process of loan appraisal, I would expect that there is a part the loan officer would be saying this loan is secured by this property. This property is, that's why for those who have offered collateral like land, there will be a valuation process so that we know this land is worth this much. There cannot be an open guaranteed amount, because we need to determine how much is the security for that particular amount. So when you sign, then it can only be for a closed amount, going by the words that member has used. It has to be for closed and specific amount that I have agreed. So that if I sign for 100,000, I'm only authorizing the Sacco, in case of default, to deduct a maximum of 100,000 from my account. Even if I have more, the more cannot be touched. It can only be touched how much I signed for, which I must have indicated on the form, and I must have confirmed if it is by email. There was also a question about a member default. There is a question about only one guarantor. The Sacco only goes after only one guarantor. As I said, it's important when you are signing the form, you know what you are signing against. It can be joint, it can be severally. Legally, those terms mean differently. When it is joint, it then means we are liable for that loan jointly, and ordinarily the amount would be deducted equally. But I know Saccos would avoid that. And you know why? It's because my account could be guaranteeing others. And it could be I have fallen a victim of a different member who also defaulted, and my deposits are no longer available. So even if Sacco was to come and recover for the borrower number B, whom I had also guaranteed, my deposits are no longer available. They were already deducted by borrower number A. So most of the institutions you will find they have the clause on severally. Severally is where they say that either of you, that is the meaning, either of you can be recovered from. So by the time they are coming for your deposit the second time, it would mean the other guarantors, their deposits are not available for recovery. And most of the guarantorship forms, it is severally. And the reason being is because we have guaranteed so many other loans. So if we put it jointly, practically that wouldn't work. So that's why, and when you have signed a form saying severally, I'm severally liable for that, the Sacco is entitled actually to just recover even from one person, if that is what is available. But generally, as we said in the policy, maybe they could have a clause on fairness. If the other people, their deposits are available so that we don't overburden one guarantor, they could say, if the other deposits are available for the other guarantors, they could go after the other guarantors. So chances are, there must have been a reason why they came for your deposit the second time, and the other guarantors, maybe no deposits have been made. There was also a question about a member defaulting. A member default as a guarantor. A member guaranteed defaults, and as a guarantor, I sent email to start paying the loan monthly for a certain period. It's okay. I think that would depend on the agreements you have with the Sacco, because when you have signed the guarantorship form, you have stepped in, you have taken the secondary liability. If the primary, who is the borrower, defaults, then that liability comes to you. The Sacco could say, maybe we deduct your deposit, but if you're offering to be repaying his monthly his monthly repayment amount, then that would suffice. But that depends with the engagement you have with the Sacco. If you sit down with them, if you're offering to pay what he is required to pay every month, then there is no change. The problem would come in, I find it, is that this person had taken out a loan to be repaying monthly, let's say 100,000, but you come and offer to pay 10,000 every month. For the Sacco, it may not work. So it depends with what you're offering, but a sit down with the Sacco would be appropriate. When are auctioneers called in? Ordinarily, auctioneers will come in when there is already a judgment, because it is even auctioneers. I know sometimes auctioneers operate kienyeji, but by the time they're operating kienyeji, I say, I call them, those are people who just come to harass you and say you need to repay this person, their deposits have been deducted and all that manner of thing. But an auctioneer who is operating within the realms of the law, then you need to have, there must have been a court judgment, because it is through that they acquire a right to execute. Auctioneer are also regulated, and there are only circumstances when they can legally operate. When they're not legally operating and appearing at night, especially during dark hours, then you can always say, these are men in black sent to scare you. Yeah. We can move to the next one if there's another question. I think that was the last one I took in. How can I, as a guarantor, get my deducted money back once the Sacco has recovered its money from the borrower? Definitely, I would expect that if the borrower has repaid the loan, then your deposits are reinstated. Whatever was deducted was reinstated if the borrower has made good of that. But what I know, there may be a charge financially, is whether you still get your interest for that period when your deposit were no longer available to earn interest. But definitely a reinstatement of your deposit should happen. What are the steps you are supposed to take to recover money if the defaulter was relieved of his or her job but has a new job but doesn't want to honor his obligation of paying the loan? This comes in where if deductions have happened, that's what I said. If already your money has been deducted, which the Sacco has exercised its right, then you could go to the tribunal, get a judgment. And if actually you know his workplace, that's very good. We just attach his salary and you get your money paid. Even without attaching his salary, the easiest always is committed to see for jail. We get a court bailiff. They can pick him up. No one wants to repay in jail. They'll just start repaying the money and even negotiate and record a consent in court that I offer to be paying this and that. Because also attaching his salary is a court process, which the court has to verify all that manner of thing. But committed to see for jail is very straightforward. They are court bailiff who are authorized by the court to pick him up and commit him to see for jail. Can I buy land? Okay, sorry about that. It appears the screen has challenges. If there is a different laptop logged in, I could be reading from it.
Yeah. Whether they can buy land in that land is used as
The security.
Yes,
Yeah.
okay.
Collateral.
Yeah, maybe I can start explaining that. Can you buy land using the Saccos finances for that? It is very possible, and we have done it for some members. This is where you would ordinarily present a sale agreement or an offer letter with the Sacco. When you present it to the Sacco, they are going to appraise your loan. But what happens is that there will be two processes taking place. There will be a transfer and there will be a charge legally, in which the Sacco will first give an undertaking to the seller. Of course, you have disclosed to the seller that you're getting financed by the Sacco. So the Sacco ordinarily give an undertaking that upon the registration of these processes, then the Sacco will repay the amount they are required, you have borrowed from the Sacco. So the simple answer is that it is very possible for you to be financed by the Sacco to buy land, in which we always register a transfer, and at the same time that property is registered with a charge securing the amount that is being financed by the Sacco. But we must understand, I think that's where the problem comes in, when you explain to someone that these are two processes that will run very closely, they don't understand, but it is very possible. We have done that for members. You just identify the land, you agree with the seller, the specific amount, you have it reduced into a sale agreement, you present it to the Sacco, then the Sacco will finance as long as your loan account allows. So I think we were there. I have seen the question right there.
Yeah, there's another question from Joel Crispo. Are there alternatives for human guarantor? Alternatives?
Yeah, the alternatives, that's what I said, is that the borrower must present an acceptable guarantor to replace you. It is only that, but it is conditional. If the borrower cannot avail an acceptable guarantor to the Sacco, it is not the Sacco's obligation to replace you. You and the borrower must present an alternative, because already the amount was already disbursed on the strength of your guarantorship. So if the Sacco, then the Sacco must always be secured at any particular point, yes. But if you present an alternative guarantor, the Sacco should not have a problem with that if the guarantor has available deposit to do that.
Thank you. Another question from Shirley Muriunki. On the issue of guaranteeing severally, shouldn't the Sacco deduct as a maximum the amount they have guaranteed? It's not clear why the Sacco would deduct twice from one person. So that one, Shirley, I can request you can also share your details on that link that we shared on the chat, so that we may also be able to reach out to you and get the details of the issue that you are facing.
Yeah, but maybe to add to that, Shadi, what you need to know is that if you guaranteed, let me give an example, 200,000, the Sacco has the right to deduct from your from your account, a maximum of 200,000, and that need not happen once. It can be in phases. Maybe this person has defaulted for a particular period of time. The amount in arrears could be this particular amount. If you had guaranteed 200, they deduct 50,000. What is available to the Sacco, there is still 150,000. If this person does not make good his account, the Sacco can continue deducting. But in total, the maximum they can deduct is the amount you had guaranteed. They have a limit of 200, which need not be deducted once. It can be in phases, but the maximum put together is 200.
So thank you. Let's check some more questions from our Facebook platform. And the first one, that is from Boniface. You're asking why the Sacco deducted the money without your knowledge, without updates. And also asking why there wasn't follow-up. I think also even as Wakili will be responding to the question, I will request that if you may also kindly register your full details on the link shared so that we may be able also to reach out to you. So then another question. What happens when I'm not in a position to pay loan and yet the guarantor? An incomplete question. I think Frida, your question was incomplete. You're asking if you're not able to, you are not in a position to pay the loan, yet the question is not complete. So maybe if you may kindly complete the question, we shall be able to respond to it well. That is Hillary. You are asking, how about if you are supposed to pay the loan today and you didn't manage to get money? Can someone pay that loan after the due date? Then lastly, if the Sacco has recovered all its money by deducting the deposit from the member, can the member agree with the guaranteed person to pay the money in cash? Yeah. Thank you.
Yeah, maybe you can handle those three. The Sacco deducted without your knowledge. It would have been expected that you received notices of the borrower's default. But also I also say, always ensure that the contacts we avail are reachable. Contact, email address, when you change your email address, did you update this information with the Sacco? Because when I joined the Sacco maybe of 15 years ago, I know that maybe the email address I'm using is not the same as I had offered. What is used to communicate to you is your registered details. So let's also ensure that the information the Sacco is holding at one particular time is the correct information we have. You change your addresses, email, phone number, residence, update with your financial institution. But it would have been expected that the Sacco would have reached you. Maybe you, as Emmanuel is saying, share your details, let them pick up. Let's see what happened with that one. The issue about paying the loan after due date, I would leave it to Emmanuel, but I would expect that you're able to always finance your or reservice your loan. Of course, it may come with penalties, but I'll leave it that to the Sacco because it's more of the internal process. It's about when the loan become due, the installment become due, and what happens in case you are past the due date. And there is the issue about the Sacco has fully recovered the money from its deposit. You know, when the Sacco has recovered its money, it has recovered its money from the guarantors. Actually, you could say that the contract between the Sacco and the borrower is done because they have recovered the money. The contract with them and the borrower, and the guarantors is also done. It's spent. It's what we say it has been fulfilled. The contract is done. So what happens is that the guarantor still has a right to pursue for the money already recovered from the account, from the borrower. Whichever way they agree to repay each other is actually where the problem usually comes in. Because with that, it is now for the guarantor to go after the borrower. They can, as I said, there could be an amicable way of dealing with this. A repayment plan would be good. If they don't, then that's what we are saying, that the guarantor has the right to go to court for the money which was already deducted from their account. But once the Sacco has fully recovered its money, it has no business with the borrower and has no business with the guarantor. The much they can do is to support either party who may be needing the necessary legal document to support their claim in court.
Thank you, Wakili. Hillary, supposing you are to pay the money today and you didn't manage to get the money, if someone can pay the loan after the due date. You know, Hillary, we are human beings and sometimes things do happen. So what we recommend as a Sacco is that you reach out early so that we have a discussion. We also have avenues where we do loan restructuring, just in the unlikely event that something happens and you're not able to meet your loan obligations. And also, in the event that you realize your loan will fall into arrears, we encourage you to reach out early to us, you communicate, then we shall pick up a discussion and reach a win-win situation for each and every one of us. So we always encourage those avenues that you as a member, you know that our Sacco bylaws do state our membership rights and responsibilities as well. So whenever you take a loan, then it's your responsibility as a member to make sure if you are in such a situation, then you reach out to us as early as possible for a discussion. Thank you. So we are still checking more questions and just almost winding up. So if you still have any pressing question, we are just winding up. And also thanking you for joining us for this session today. I know we did plan and finally you got the time to join us. So let me just check on chat if there are any more questions that are still pending. Wakili, a question from Frida Mora. Does the borrower have a right to know why some guarantors are rejected?
I would say the simple answer is no, because at that point, there is no contract that has accrued between the guarantor and the Sacco. The Sacco has the discretion to accept or reject any security. Even when you offer your LAD, not every LAD will be used as security. It may not be within, it may not meet all the criteria the Sacco is looking for, because the Sacco does not accept just any security. It must accept a security that if there is default tomorrow, that security, whether guarantors or whether LAD or motor vehicle, can satisfy the loan amount. So there is no right, the Sacco has the discretion to accept or reject the security.
Thank you, Wakili. And I saw Lydia Nyarimpo, you are referring to a question that has not been answered. So I will request if you may kindly share that question once again. Then Lucy, you are saying that you are deducted all your shares to pay someone's loan, and the person in charge of the loan kept on hiding details of the person you had guaranteed. How do you get help? So you will get help by sharing your details on the link we shared, so that you indicate your membership details, and we shall be able to contact you just to be able to assist you. Lydia, you're asking your question in line with the issue with the term severally. In a situation where one guaranteed a loan via email without any forms, which terms apply for this?
Okay.
Wakil, if you may kindly respond to that one.
Yeah, it's also depend on the policy of the Sacco, and that's what I was saying. The Sacco has a discretion, but a two-step verification or a personalized way of verifying that the person has guaranteed is one ideal. And in this case, I could see an email was sent to you, which you confirmed. But when the email comes, it comes with some terms. And it would say, are you agreeing to guarantee? Let me say, by I also received an email when I was guaranteeing a member, which for me I felt would have been sufficient, but if I wanted more details, I would have asked, which would come and say, are you agreeing to guarantee by a sum of Kenya shilling 100,000? If I want more details, I could respond and say, I need more details or 1, 2, 3. But what applies is that you have guaranteed that person the money, and it is presumed that you have knowledge of what you are guaranteeing. So the terms that applies is the terms of the loan. That person must have applied for a loan. They must have been granted a loan with a repayment period, with the plan on the installments, how they are going to repay the loan. So that's what happens. If you already accepted, then it is presumed you have accepted to the terms of the loan. If you need it, and that's what I said, you have the right to ask for more information. And do not accept until the information is supplied to you. And if it's not supplied to you, the answer is simple. You say, no, I do not agree to guarantee. But when you have accepted and the Sacco has proceeded to act on the loan terms as applied by the borrower, you are presumed to have accepted to the terms upon which the borrower was given that loan. If a guarantor,
If a guarantor has specified an amount to be deducted in case of a default by the borrower, can the Sacco go ahead and deduct an amount that exceeds the specified figure in the loan contract?
let me specify that what should be deducted from your account is the amount guaranteed. It's not the amount of the loan amount. Actually, the amount on the loan contract can be way higher. I could be taking a loan of, let's say 1 million, but one guarantor guarantees me only 100,000. That guarantor can only be deducted that 100,000, not the 1 million. So what is deducted from you is what you have committed yourself. If you committed to the full 1 million, 1 million can be deducted from you. It's not about the amount given to the borrower per se, but first, there is also the question of what is the loan outstanding? That's question number 1. But the second limitation, so that I may have guaranteed 1 million, but the loan outstanding is only 500,000. So they do not deduct the entire 1 million. They'll go for 500,000. But also the second limitation is the amount to be deducted is limited to what I signed for. If I signed for only a specific figure, that's the maximum the Sacco will deduct. But cannot be higher than against the loan outstanding amount. What if you did not specify because there was no form, just an email? For good order, I would have expected the email specify the amount you are guaranteeing. And this is what I am also saying, as a member, if you feel that the information supplied to you or requested of you is not enough, always clarify some of these things. Because maybe a loan officer did not include all the details you needed, don't confirm that email. The simple answer is do not confirm until you have all the information you want. And even when you respond, you can always respond with the limitation. You can say, I confirm, but I only confirm to the extent of this particular XYZ amount. But an email coming to you without specifying an email, then the other question would be, what did the email indicate? I would have expected there is a specific figure, since there was no forms. But if it's an issue that you want to confirm, maybe you can pick it up with the Sacco. The challenge that comes, I always say that at the time of signing contracts, there are no problems. In fact, we sign without mostly paying attention. The point of implementing or enforcing those contracts is when we start asking, what did the contract actually say? So if you want information, it's good. You can always ask the Sacco to supply the information. I'm not saying you may have signed any form, but it is good now to be supplied with the information so that you know what happened at the time, because you did not expect that this borrower would default. Who would sign for a borrower knowing they would default in the future? No one would sign for them. But it is only until they default we start asking ourselves the hard questions of how much did I sign, what happened, and then that's why the Sacco should have records of this. So share your details. I think Emmanuel and the team can supply you with the necessary information. But all in all, what we are saying, all is not lost. What we should be looking forward to, if recovery has happened, you have a right against the borrower to recover the amount that's already deducted.
Thank you. Wakili, some of our members on YouTube, a question from James. What if a defaulter who is still in employment gives promises but never honors them? Almost 2 years 2 years down the line, he's still owed. Then there is a question, another question from Kevin. Can a title deed be used as collateral? Yes, that is correct. It can be used. Then another question. Wakil will be noting down the questions that she will respond to our members on YouTube. Wakili, what is the role of the Sacco in the loan recovery, and what steps do they take other than just deducting the guarantor's deposits? A concern from Nancy. Noting a concern about the Sacco not assisting when it comes to tribunal. Okay.
I can take those ones first.
Yes, you can.
As you get the others.
Okay.
So I'll start with a defaulter who is in employment of 2 years not honoring. That's what we said, the remedies of recovery. And these ones seem not interested in repaying the loan. Is what we are saying. There is the tribunal process. You can approach a lawyer, or if you have time, you can file a claim with the cooperative tribunal. You'll get your judgment, and it's good when you know that they're in employment. I say the best thing you can ever have is a case when you know where the defendant lives or work, because the moment you have a judgment, the following day you just go after them. The worst happen is when I just have a judgment and I can't take it anywhere because I don't know where this person lives or where they work. Can a title deed be used as a collateral? We said yes. Maybe we'll have a session on collaterals, but it's still when you come to the Sacco, they'll guide you on that. There is the role of the Sacco when it comes to recovery, apart from deducting the guarantor's deposit. And one of their role, of course, is to supply you with the documents. That's number one. Number two, they kept notifying you of the default by the borrower. But more importantly, let's also look at it this way. The loan was disbursed on the strength of your undertaking, that if this person defaults, I will repay. In fact, by them notifying you is a matter, I would say, is courtesy. It's a matter of courtesy. It's only that they don't want to get you off guard. But that money, which is members' money, was given to someone on your undertaking. So let's also see, as much as we expect much from the Sacco, it's my obligation when I undertook to do something. Then when that time comes and it happens, then we can't blame the Sacco. What happens when the Sacco is not assisting when it comes to the tribunal? There is a very limited chance the Sacco will assist. One, when that borrower still have an outstanding amount that the Sacco want to bring a claim against that borrower, in which case they can join you as co-claimants, so that you bring this case together, and the Sacco would be saying, as we had given him a loan, we have recovered up to this amount, there is this outstanding amount, we are claiming this balance. Which also you can step in because you're also from the same subject matter of that particular loan and say that our money was deducted, our claim is for the deducted amount. It becomes easy at that point. But when the Sacco has fully recovered its money, they cannot bring a claim against that borrower, even on behalf. The reason being, there is what we call about locus standi in court. What will be the locus of the tribunal in court? Actually, they will be asked one question. What do you want? What is your right? You have already recovered your money. What do you want? So the much the Sacco can do when they have fully recovered, since they cannot bring a case, even on your behalf, they cannot. They do not have locus at that point. They have no case to bring. Remember, in this other case where there is an outstanding amount, they can join you as co-claimant, in which then they can pay a lawyer as who is representing the Sacco will represent the other guarantors whose money was deducted. But when there is full recovery by the Sacco, the much they can help you is with the documentation and with the information, which then you have to take up the case by yourself. And also, I have also seen even where, because I represent the Sacco in some of those disputes, and we tell them, I think it's good for members whose their money was deducted, join them as claimant. There is no extra coin. The Sacco is either way paying the lawyer. But the challenge has also been some guarantors then turning against the Sacco and saying, but we didn't give consent for you to include our names. Even when they were the ones making noise at the Sacco offices and saying, help us to pursue this person. I don't know when now we get to the tribunal, I think the borrower come and promise to repay them and all that manner of things, and now they turn against the Sacco. So we have had challenges where the Sacco has even joined other claimants in good faith. And then these co-guarantors come and say, no, we did not authorize for this lawsuit. So also the Sacco tends to be a bit careful, because in court, by the time they're instituting a case against another person and they have to join your name, you must have given a clear consent that you want to be part of that case, to avoid the Sacco being embarrassed. I think we have had that scenario where we filed a case. I think the co-guarantors agreed with the borrower without informing the Sacco, and the Sacco is learning about it when you're already in court. It's also good. We are not saying people don't agree. Actually, for me, I encourage out-of-court settlement. It's good. It isn't the pressure among us. We are not here as members to sue each other so much. Our self is to grow each other. But when we have ended up at that point and you have agreed with the borrower because you may be colleagues, out of courtesy, come and inform the Sacco. I know we have filed a case, but we have agreed with my brother here And the Sacco will be like, it's okay, let's now inform the lawyer respectively, and we are not running about it in court and all those manner of things. Yeah.
Thank you, Wakili. The last question from YouTube, and our YouTube followers, I will request you also register your details on the link we had shared earlier, so that in case you have a concern that needs follow-up, then we shall be able to obtain your contact details and reach out to you. So Stephen is asking, how can he recover his money from a defaulter who defaulted because of losing a job and then gets a job in another company?
I think we have answered that question again. If that person has gotten a job amicably, you have tried to get them to repay, they are not repaying you your money or compensating you, the process is do a demand through an advocate or even yourself. The next process is a claim in the tribunal. The tribunal process will follow. You'll get a judgment and recover the money. I have been saying the best is when you know where people live and where they work. You can always find them.
Thank you. And the last question from Zoom, is it mandatory requirement by law for the Sacco loan contract to specify whether the deduction will be done severally or collectively?
Is it mandatory requirement by law or the Sacco contract to specify whether deduction will be done? Yeah, for good order, you would collectively, you mean jointly. For good order, the loan form should be specifying that, and where it's not specified, the law will presume it is severally. That the Sacco can go after either of the guarantors. Actually, the law is always hesitant to presume jointly because of the impracticability that comes with that. So if the form did not specify, because I said these processes improve over time. What the Sacco was doing 10 years then is not what it's doing today, because also the financial space has changed. If the form did not specify then it will be presumed severally. Where it has specified, and hardly will you find financial institution committing to jointly. Hardly. Most of them will be severally. At the part where you are signing, there is always an introductory paragraph. Let's read the finer details, the small writings.
Thank you so much, Wakili, and I want to believe that members, you've really been enlightened this evening. And Wakili promised that she'll be doing a session for us on collateral, and being one of us, a member of Maisha Bora Sacco, I know that she will once again deliver it to us. So let us look forward towards that particular session. When the time comes, once again, we shall be able to inform you. I want to appreciate you wherever you have been following us from, whether it is within the country, outside the country. Feel much valued as a member of Maisha Bora Sacco. Tuungane kwa Maisha Bora. So I want to give it now to Mr. Or just a moment, we had some questions that we wanted to ask you, because you've really been asking us questions. So we want to ask you questions so that then we can gift you with a token of appreciation, that is in terms of airtime. So the first question, kindly give a brief history about Maisha Bora Sacco, indicating the timelines for the name transition to the current name Maisha Bora Sacco. Kindly give a brief history about Maisha Bora Sacco, indicating the timelines for the name transition to the current name. That is question number 1. So if you got the question clearly, kindly you make sure that you share the answer in the link that we provided you with. Then the second question, now from the topic that we've been discussing, who is a guarantor? Who is a guarantor? And what does signing to guarantee another member mean, and what are the guarantor rights? That is one question. That is just one question. Who is a guarantor? What does signing to guarantee another member mean, and what are the guarantor's rights? Okay? You also respond to that question so that we get your feedback. And lastly, state one mobile loan facility and one long-term loan facility, clearly indicating their features. Kindly state one mobile loan facility and one long-term loan facility, clearly indicating their details or their features, the loan features for one mobile loan facility and one long-term loan facility. So kindly respond to those questions, then make sure you share your feedback and the answers through the link that we shared on our platforms. So therefore, lastly, we are going to have a session of vote of thanks, and I wish now to give it over to Mr. Mbae. Feel most welcome.
Once again, thank you, Emmanuel. I want to take this opportunity to thank our members for their patience throughout the session, and also for the interactive session that we've had. We've gotten an opportunity for them to ask their questions, and they've been adequately answered to. And to our facilitator, Wakili Wanjiku Thiong'o, thank you very much. That was an insightful session. Our members have learned a lot. It has been one of our pain points, and we really are grateful that you found time, even as our member, to come and give us this knowledge as far as guarantorship is concerned. So we are really grateful for this. And to our members, Wakili will be sharing the notes with us so that we can onward share with you for your future reference, so that at least you can be able to, get into details or deeper understanding of what we've been discussing today. So thank you so much, our facilitator, for this great session. We shall be back again so that you can educate our members more about now acceptable collaterals. Thank you so much. Back to you.
Thank you so much, Mr. Mbae. Thank you, Wakili, our learned friend in the house. And we have really had the insightful information about what the law says about guarantorship, and I want to feel that it has been quite an enlightening session. Once again, until we meet the next time, we really appreciate you. Tuungane kwa maisha bora. So we are going to have the closing prayer, and I wish to humbly request Wakili to pray for us so that I realized she's not currently mic'd, and we may ask Mr. Mbae to please close for us with a prayer. Asanteni, tuungane kwa maisha bora.
Thank you, Emmanuel. Thank you, everyone who's made this session successful. And to our members, thank you also. Enjoy your evening. Let's bow our heads down for our word of prayer. Our dear and everlasting Lord, we are before your presence this beautiful and blessed evening. We want to thank you for our members. We want to thank you for Maisha Bora. We want to thank you for the great session that we've had. We want to thank you for our Wakili Wanjiku, who's taken a time to take our members through this particular topic. We know our members have been educated on the same. We want to thank you for enabling us, and also for making sure that everything has worked as a planned. We want to thank you. We want to glorify your name. And as we retire back to our homes, and even as our members also retire to their beds, we want to pray that you protect us, you watch over us throughout the night, and when we wake up early tomorrow, we shall glorify, we shall be grateful to you for a gift of life. Guide us and protect us all through this, we pray, believing and trusting in your holy name. Amen.
Amen.
Amen. Thank you so much. Tuungane kwa maisha bora. Asanteni.